Good morning, everyone, and welcome to today's session, Misleading and Deceptive Conduct, a mid-year roundup and refresher for 2021. I think the invite may have even said how to minimise the risk of falling foul of the Australian Consumer Law, and hopefully today, with information provided, I'll give you some insights and some information which might help you avoid being subject to a misleading and deceptive conduct claim. I'm Jason Sprague, a partner in our corporate and commercial team here at Bardia Perry. I'd like to begin by acknowledging and paying my respects to the Gadigal people of the Eora Nation, traditional custodians of the land on which we are broadcasting from today. I'd like to pay my respects to the elders past, present and emerging, and acknowledge all Aboriginal and Torres Strait Islanders joining us today, and also pay my respects to your elders past, present and emerging. Before we get started, I'd like to go over a few items so you know how to participate in today's event. You'll have the opportunity to submit text questions at any time during the webinar by typing those questions into the box found on the control panel. You can send in your questions at any time, but I'll only answer those at the end of the webinar, time permitting, and subject to the questions not being too hard. So moving on, to get started, I thought I'd put some context. Misleading and deceptive conduct is a very big topic. There are numerous cases on it. It's a 23-word section in the Australian Consumer Law, and Section 18 is the most litigated piece of legislation in Australia. So borrowing this quote from the Hitchhiker's Guide to the Galaxy, it's big, just like space. That means today's seminar will be limited in terms of the depth we can go into, and it'll be fairly high level, a bit of a helicopter view. But hopefully that will give you enough insight into what the issues are, misleading and deceptive conduct. So by way of outline, what we'll cover today is I'll open with a summary of what misleading and deceptive conduct is and how it ties in with other actions which are generally tied to it, such as trademark infringement and Section 29, false and misleading representations. I'll look at the key principles which the courts look at in determining whether misleading or deceptive conduct has occurred. I'll then look at the common pitfalls for business, see where they come unstuck, looking at some examples. Some of those will be very obvious as to why they've fallen foul of misleading and deceptive conduct claims, others not so much. I'll then turn to some recent cases. I'll look at two cases, one with the ACCC's recent victory over Google, and also look at the hashtag and in-out burger cases to give an example of how the courts apply their principles to real life situations, and also look at two upcoming cases. The first one being a case which the ACCC is running against Lorna Jane, and the other one which has made lots of headlines between Hungry Jack's and McDonald's. And I'll round off by having a summary of some trends and takeaways and give a little bit of a snapshot of what we discussed today. So Section 18, Australian Consumer Law. It applies across a broad spectrum of conduct, and that can be whether it's directed to the public at large or to two individuals negotiating a private contract. The key factor for misleading and deceptive conduct under the consumer law is its conduct. So Section 18 says a person must not in trade or commerce engage in conduct that is misleading or deceptive or is likely to mislead or deceive. When you compare this to trademarks and the infringement of trademarks, a trademark under Section 120 is infringed where a person infringes or is a trademark if the person uses as a trademark a sign that is substantially identical with or deceptively similar to the trademark in relation to the goods and services to which it is used or applied. So it's a very key difference between the two heads of action here. Section 18 is all about the conduct that occurs and the time that it occurs. Now, what's misleading or deceptive is, of course, not defined in the ACL, very unhelpfully so. So we do rely on case law and judgments to get insight into what that might mean. The threshold test is the overall impression of the conduct, whether that actually induces or is it capable of inducing somebody to go into or fall into error. As opposed to a trademark situation, the threshold test there is actually the impression of the marks and what that actually leaves in the mind of a consumer and whether or not they would have an association between one mark and another mark. So it's all about the marks and how that impression is left in the minds of an individual. The two are similar in terms of some of the tests. There's no intention required, it's simply a question of fact. Did the conduct that occur, was it misleading, or are the marks on an analysis, on a review side by side, are they deceptively similar, and how do people interact with those particular marks? And for both situations, you don't actually have to prove that anyone is actually misled or deceived. It's simply whether or not it's likely to have happened. And those are some of the elements which make this quite difficult for parties to grapple with. It's this whole concept of what is likely, how is somebody going to be misled, what are the thresholds for those particular situations. The unfortunate answer is there is really no threshold because it's all contextual. It's all on a case-by-case basis, which is what makes it so hard sometimes to determine whether or not you are engaging in misleading or deceptive conduct. So Section 29 is usually tacked onto a Section 18 claim, particularly by the ACCC. It supports Section 18, and while Section 18 is very general, very broad, Section 29 is actually quite specific and deals with specific instances of misleading representations in relation to goods and services. While Section 18 is is misleading or deceptive conduct, and Section 29 is false or misleading representations, there's actually no difference in how the court applies the test to both of these sections. And in terms of false, it's a common definition, just means contrary to fact. Your knowledge of the truth is actually not relevant at the time. So you might say something believing it to be true, but if it turns out to be false, you can still be held to be in breach of Section 29. The reason why we have these two sections and why they're often tied together is because under Section 18, there are no penalty provisions. You can sue for damages, and there are provisions around injunctions, but for Section 29, as well as those remedies, you also have the ability to be fined. And those fines are quite significant now. So for corporations, up to $10 million, or 3 times the value of the benefit obtained from the conduct, or 10% of annual turnover. And for individuals, it can go up to $500,000. So for those reasons, you see Section 18 and Section 29 tied together to give greater scope for remedies in an action. This is just a brief list of the various things which you shouldn't do in relation to goods and services under Section 29. They're all fairly obvious. You look at them in isolation, you go, well, it's pretty obvious the things you should and shouldn't do. However, people being people tend to like to be clever, and unfortunately, that cleverness sometimes leads them to fall foul of these particular sections. Advertising, of course, is the area which is the classic. People want to draw people in to acquire goods and services, and boundaries are pushed, and very often you get this whole tension between, well, what is good marketing or clever marketing compared to illegal marketing. Many years ago, I was speaking to the General Counsel at Hyundai. He was complaining to me that his marketing people didn't like him and called him the anti-marketing department because he would always say that you couldn't do certain marketing campaigns because of this particular problem. I don't think they realised that the cost involved getting it wrong was quite significant, and so we have that tension between wanting to sell product and get it out there and complying with the law. So looking at principles which the courts apply to determine misleading conduct, the key thing is context. Context is what matters, and it's always going to be determined on the basis of when the conduct occurred and what facts were around at the time. And this is what makes it quite difficult to determine in a lot of circumstances whether conduct is misleading or deceptive, because often in hindsight, when you look back, 20/20 vision is a wonderful thing, and you can actually unpick the issues to determine the conduct. But at the time you make those representations, you may not be aware you are actually misleading somebody. It's also wrong to select certain words or acts in isolation, and again, it's the whole issue of context. And an example of that context was a case between Telstra and Optus last year, where Optus had some ads running that with a tagline covering more of Australia than ever before, which was in reference to the network. Telstra argued that that particular slogan or saying was implying that Optus's network covered more of Australia than any other network in Australia, including Telstra's. Optus argued and said, well, no, it's only our particular network that we're talking about. In terms of determining the case, Justice Jago emphasised that context is all. And in that particular case, when the ads were analysed, they were very clearly associated with Optus's well-known Yes branding. The Yes branding occurred prior to and after the use of that particular slogan. And in terms of how that would be interpreted by an ordinary person or the reasonable person that the information was aimed at, the campaign was aimed at, the view was the only reasonable meaning is the one proposed by Optus, was that it referred only to Optus's network. So keep the context piece in mind when we look at the Hungry Jackson McDonald's case, and we'll see how we can apply the particular contextual facts to determine what the outcome of that case might end up being. A key factor also is that you must be led into error. You can't just be there thinking, oh, I wonder if that's correct or not, or be confused. There must be some act or decision made on the representation which causes an error. A classic example of that are the Nurofen cases, or I should say the Nurofen case, where Nurofen was being marketed across several different product lines, yet it actually had the same formulation. It was the same tablet, just packaged differently and marketed differently. The problem was, with the marketing, people were paying higher prices for some of these more targeted pain relief products, which were actually no different to the bog standard Nurofen that you'd buy for general pain relief. And those are the things where someone is led into error, where they think, I'm relying on this information, I'm buying a much higher priced item, and therefore the error occurs. Direct connection is fairly obvious. Essentially, it's got to be your conduct which causes someone to be led into error. If there are third parties involved or other instances which might take away from the error being made because of other people's actions, then you're not likely to be deemed to be engaging in misleading or deceptive conduct. So who must be misled? As I said at the beginning, it can cover the public at large, depending on how it's aimed, or two people negotiating a contract. Where the public is involved, you need to consider the class of persons who are likely to be affected by the conduct. And that's not always the easiest thing. And we'll come to this when we look at the ACCC and the Google case, determine who the class of persons was. It's quite an important concept. Now, in terms of the number of persons who need to be misled, that's actually not relevant because, oh, sorry, there we go, go back to the right slide. Or, oh, sorry. Nope, there we go, apologies. So in determining the number of people, there was some discussion previously around a not insignificant number of people had to be misled. That test has been pushed to one side now. Essentially, it is if a reasonable person in the class of persons who the conduct is aimed at is likely to be misled, then that's sufficient. It doesn't matter if it's 1, 2, 100. The view is if a reasonable person would be misled, it's likely most of those people would be misled. The section doesn't, however, protect people who try to care their own interests. And the example of that is a case which was considered in the New South Wales Supreme Court, where a gentleman was acquiring a business and he was very sophisticated, he was well resourced, and there was information which wasn't disclosed by the vendors, but he proceeded to purchase the business anyway. And he did this because he said he had not enough time, essentially. So he took the risk. The court held, you're a sophisticated person, you know what you're doing. You chose not to actually undertake searches which you could have undertaken. You gambled and you lost. You weren't misled despite the fact that these people didn't tell you the information that was required. And so they didn't engage in misleading and deceptive conduct. So it's very important to sort of look at the context of the individual or the people who are subject to the conduct, because their circumstances might dictate whether or not they've been misled or not. The intent to take care, there's no intention required for a breach of section 18. It might be something which the court considers in determining whether or not conduct has been misleading or deceptive, but it's not determinative of that particular situation. Simply put, if the facts indicate that conduct is misleading or deceptive or likely to be misleading or deceptive, that's sufficient. It doesn't matter whether you intended to do that or not. Similarly, there's no requirement to take reasonable care. You can be doing something in all good faith and honestly, but still be potentially liable for a breach of section 18 if the conduct at the time turns out to be misleading or deceptive. There must be a real possibility that somebody is misled or deceived. And again, this is a very difficult one sometimes. It mustn't be just a mere or fanciful issue or situation. A fanciful assumption might be that because a person sells goods, they're also the manufacturer. That's clearly not always the case and a fanciful view of things. In terms of the remote chance, it's not more than 50%, it's not less than 50%. So it's just simply what the court deems would be a significant possibility. Significant is probably not quite the right word, but a real possibility. So it could be 30%, 20%. It just depends on the context and the way the court might interpret the number of persons that are going to be affected by the particular conduct. Opinions can be quite difficult to sort of grapple with at times. It must be clear that an opinion is the opinion of an individual and that the person you're conveying that opinion to understands it's an opinion. Generally speaking, opinions are not misleading, even if they turn out to be incorrect. However, if you're an expert and you express an opinion and there's a belief that the opinion is based in some sort of reasonable fact and logic, expertise has been applied to obtaining or coming to the opinion, and you provide that to another person and they rely on that, you could be in breach of Section 18 if it is found that the opinion in which you made was not actually based on anything reasonable. So it was a reckless statement. So for example, myself as a lawyer, I'm expressing various opinions throughout this particular presentation. If they had no foundational basis and you relied upon those, then I could be in trouble. But of course, everything I'm saying today is purely based on good foundation and applying my expertise here. Timing and mitigation is another thing which the courts look at. And respect of timing, it doesn't matter when the conduct occurred, how short the conduct was, how long it was. The fact of the matter is, if the conduct occurred at a particular point in time and it gets assessed as misleading and deceptive, there can be a breach. Timing becomes an issue mostly in determining whether or not the extent of penalties and what the damages might be. And that'll also be dictated by context. So you could have a period of breach which might be 6 months or 12 months, but only a small number of people might be subject to that particular misleading or deceptive conduct. And you may not have a large number of people affected, and the actual damages could be quite low. But you may also, on the converse side, have a situation where you have a short period of time, and we'll come to a couple of cases on this, where a large number of consumers are affected. And because of that large number being affected, the penalties may be significantly higher because of the policy of protecting consumers under Section 18. An example of some of the timing issues was a case, this is going back to 2011, between the ACCC and TPG Internet. TPG Internet was actually offering unlimited internet services. And they were saying on their front page, unlimited internet services with almost no further information in terms of any disclaimers or anything of that nature. TPG said, well, that didn't really matter because you could click through to our terms and conditions. It actually showed to get this unlimited service, you actually had to get a bundled phone line and pay additional costs. And that was only very transitory because you had to click through to the terms and conditions to acquire the product anyway, so people should be reading them. The court said, well, no, in that particular case, it doesn't matter that it's transitory. You haven't actually given people proper disclosure. What you've done is you've buried things within your terms, and people often don't read the terms. Now, compare that to people who may not be able to sustain a misleading action conduct because they don't do their own particular research. This situation with ordinary consumers, while we're encouraged to read terms and conditions, we don't always read terms and conditions. And the court has said, well, in some of those situations, unless there is very clear information provided about some of the limitations of what you're getting, you may be engaging in misleading and deceptive conduct. Mitigation is also another important factor, particularly when it comes to damages and penalties. Mitigation is generally going to be whether or not you have complied or met the ACCC, complied with their requirements, and in terms of court proceedings, basically you rolled over. So that sort of compliance, that sort of being a good corporate citizen once you've been caught, will often see a reduction in damages. Also, with conduct that has occurred, once you've been informed that there could be a breach even though it hasn't been proven, if you take steps to mitigate that, that can be very useful in terms of looking at penalties. The Oscar Wiley case, where Oscar Wiley was advertising that they would actually send a pair of glasses frames for every pair of glasses that you bought to people in need, was found to be false. So in the period which ACCC has looked at, I think Oscar Wiley sold 300,000 pairs of glasses, but only actually gave away 3,000 frames to people in need. Once the ACCC got wind of what was happening and made the allegations against Oscar Wiley actually turned around, started to do the one-for-one, made contributions to charity, and basically played ball with the ACCC. The ultimate culmination of that was a 30% reduction in the penalties that may have been assessed against Oscar Wiley. So again, that whole mitigation piece is quite important. Having said that, mitigation does not take away from the fact that breach may have occurred. You can realise there's a breach, fix the issues and the conduct, but still be held liable for the breach, because at the time that breach occurred is when it'll be assessed. So what are some of the pitfalls for business? Let's have a look at that and apply some of the, or look at some of the not so obvious issues and some of the obvious issues. The first thing I'd like to just remind everybody is that the monetary thresholds are increasing from 1 July 2021 from 40,000 to 100,000. This means you're going to capture a larger number of consumers, a larger number of goods and services, which will then fall within that threshold and be subject to the consumer laws and Section 18. So bear that in mind with your businesses and just get ready for the fact that you may have more unhappy people and there's a potential for more claims to start to spin out of Section 18, not that we don't have enough already. Multiple meanings, half-truths and literal truths. This is a classic in terms of a lot of the marketing materials. Every marketing piece generally likes to be quite clever, funny, try and spin things in a certain way and skate quite close to the wind, or actually skate close to the edge between clever marketing and misleading and deceptive conduct. An example of a literal truth would be if I put out an invitation to everyone, say for example today, and said, for one day only, come and see The Rock. Most people are going to think that's going to be Dwayne Johnson. Maybe I've just got a close connection, I've got some special deal going with him, and people come to this webinar to see The Rock. You come onto the webinar and what you see is a picture of a rock, and that's The Rock. But quite clearly it's misleading because people would think it's going to be Dwayne Johnson and not just a rock. Same thing if you have a concert, say an Ed Sheeran concert, or you announce a show, I should say, where Ed Sheeran will play, and then the person who turns up is some unknown talent who just happens to have the name Ed Sheeran. Again, that's going to be a literal truth, but it's going to be misleading and deceptive. Silence is a big one. It can be quite difficult to know when you're allowed to remain silent or when you shouldn't remain silent. But it's really going to be a situation where you should know better. If there's a situation where there's a reasonable expectation that disclosure should be made, then you should probably make it. Yes, it can be hard to often determine where that line is, but often it's a gut feel. And if you were to acquire a product and you wanted that information to be provided to you, then that's really the litmus test. It's really not that hard to try and work out what you should and shouldn't disclose to avoid misleading and deceptive conduct. There are other reasons why you don't disclose. That's quite understandable, but not necessarily going to save you when you get a claim for misleading and deceptive conduct landing on your desk. An example of where silence was deemed to be very serious and significant penalties were imposed was the 2018 case of ACCC against Thermomix. Thermomix were aware that their product had a very loose lid, or sorry, the lid would actually work loose over time, and that could actually cause people to be sprayed with hot liquids and suffer burns. This was a known safety risk as well. It was not just a one-off thing, some boffin in a factory somewhere. It was actually known through management, through the organisation. Yet they still remain silent and didn't say anything about this. ACCC argued that by that silence, they misled people into thinking the product was safe. And a reasonable person would assume that a company, knowing a risk of that nature, would disclose it or put a warning label or something on the product. Having failed to do that, there was a understanding that the product was safe. People then, of course, bought the product unaware of the risk, and they were misled. And that misleading conduct led them to buy the product when they may not have otherwise done so. Similarly, internet companies offering unlimited download plans, not disclosing that it's unlimited, but subject to speed reductions after a certain amount of downloads. Those are the sort of things where you're not disclosing the full information or detail, and that silence is going to make you come unstuck with a misleading or deceptive conduct claim. And I've also already mentioned the particular case in relation to the New South Wales Supreme Court, and that case was actually, it was Warmold v Maricata in 2020, and that was about the individual who was acquiring a business and failed to take proper steps. While the vendors were silent about certain information, that's information which, in that particular case, that individual could have obtained if they'd done their proper searches. Pricing. This is another classic which often gets businesses unstuck. Having the correct price, not moving prices before sales, all this sort of conduct is where a lot of businesses have been found to engage in misleading and deceptive conduct. Example here is Kogan, the internet shopfront. In December 2020, they were convicted of misleading and deceptive conduct after running a campaign which only ran for 3 days, mind you. Between the 27th and 30th of June, they ran a 10% tax time promotion, so giving people a 10% discount on their products. The problem was that one day prior to the offering, they increased the prices of products. And then 2 days after the offer ended, they decreased the prices of products again. So the people who actually bought the products thinking they had a 10% discount really got no discount. They were being misled. Now, Kogan argued that they changed their prices quite a lot, and that was accepted by the court. However, the court said, despite that, the timing was quite clearly inappropriate. Perhaps if it had been 2 weeks prior or 3 weeks after, some greater time period so people could understand there'd been an increase in pricing, they would have been misled, or less likely would have been misled. But they're the sort of things which companies often do. Another example which ACCC has on their website is one in relation to Audi Australia. And that was back in 2008, where Audi was offering the Q5, the Q7 series for sale. And it was, the advertising was such a nature that it looked like the 7-seat configuration was a standard configuration, when in fact it was the 5-seat configuration. Also, the pricing indicated that the drive-away price was around $80,000, which people thought was for the 7-seat variation. But in reality, that was for the 5-seat variation. When you wanted the 7-seater, you had to pay extra for dealer charges, statutory charges, and also the extra 2 seats, which actually bumped the price up to about $89,000. The context of that advertising in the Sydney Morning Herald and the Age was deemed to be misleading and deceptive because of the way it was promoted to individuals without being clear in terms of what the actual charges were and the difference between what was standard, being a 5-seat configuration versus a 7-seat configuration. The next one I want to look at is the compliance and training. This is an important piece for organisations in terms of mitigating penalties if they are subject to a claim for misleading or deceptive conduct and found guilty of that. The cases always look at what steps have organisations taken internally to make people aware of misleading and deceptive conduct issues. If you don't have a compliance program in place, the courts tend to order one to be put in place. And also the costs or the penalties imposed for the lack of compliance and having provisions in place tend to increase the penalties. This is because the court's view is, well, you're not taking it seriously. People should be aware you're engaged in business. It's a very important thing to protect consumers, and your organisation should be geared to understand what the risks are and what the obligations are in respect of complying with the consumer laws and not engaging in misleading and deceptive conduct. So for organisations out there who don't have a compliance program, I urge you to look at that and put one in place if you are marketing and selling goods and services, because it can be quite, or not quite, is very important if it ever comes to a dispute or a claim being made against you. And those programs don't have to always be bigger than Ben-Hur. They can be tailored to your particular organisation size and needs, but having something there is going to serve you in good stead should the claim come at some point in time where a mistake, or just where a mistake is made. As I said, it may be inadvertent, but that doesn't necessarily protect you from a claim of misleading and deceptive conduct. Small print and disclaimers, that's fairly straightforward in terms of why that can be an issue. If you hide important information in the fine print, don't make it obvious or accessible, then it's going to be a situation where you could be engaging in misleading and deceptive conduct. It will depend on what you're doing. If you're in print, then depends on how much, I suppose, how big the print advertisement is, the size of the print, is the important information in bold or italics or underlined, or is it hidden in other areas? Things on TV, again, are quite different in terms of how the context might be viewed, because if the disclaimers are on the screen for a very short period of time, that may be deemed to be insufficient to displace the dominant message in the ad, which could be misleading without a clear disclaimer actually explaining that particular message. Keep in mind this particular point when we look at the ACCC and Google case, because that's it's very much a key issue which the court considered in determining Google's guilt in terms of engaging in misleading and deceptive conduct. Asterisks, same sort of thing, you can use those, that's all fine, just make sure it's prominent. It's a difficult thing sometimes with marketing and advertising space about how much you have to provide to disclaimers, but again, if you look at it, you read it, and you think the disclaimer is not particularly sufficient, or ask a few people, just make it more obvious. That will generally help you and save you from a claim of misleading and deceptive conduct. Like anything, it's always on a case-by-case basis. The courts will have to assess everything based on the time of the conduct when it occurred and how that was interpreted by the people the message was conveyed to. So predictions and forecasts. It's fairly obvious that if you make a forecast or a prediction, it can't be made with reckless disregard. There must be some sort of reasonable grounds for representation to be made. If you have no reasonable grounds, then of course you're going to be subject, or potentially subject, to a misleading or deceptive conduct claim. Proper inquiries we've touched on, and I refer again to the case where the vendor acquired the business without making due inquiries. But then contrast this with the case which was determined by the High Court might have been 2 years ago now, where the High Court upheld orders made by New South Wales Department of Fair Trading against some developers for misleading and deceptive conduct, where they were selling waterfront villas as permanent residences, but those permanent residences were actually in caravan parks, and they had no planning permission to be a permanent residence. These were sold often to retirees who purchased these premises and later found that they didn't have the right to stay there permanently or have it as a permanent residence. In this instance, you might think, well, surely they could have obtained advice, they could have done some searches, got a section 149, and it would have seen there was no planning permission for a permanent residence to be there. That's all true, but in this case, because of the class of persons being the retirees, they're less likely to be as informed. They're not going to be necessarily as cashed up as the person was who acquired the business. And there's also selling techniques and pressures which are put onto people to sign contracts and enter into these arrangements prior to getting advice. And it was those sort of techniques of selling these properties, also representing that they're experts, they're builders, you can rely on us. Why wouldn't you rely on us? Just sign the contract here and off you go. Those are sort of things, the sort of conditions where the proper inquiries argument didn't support the defence. And it was said, no, you actually engaged in misleading to the conduct because you should have disclosed this information. And it didn't really matter that the purchaser sort of made inquiries. They're in a class of persons who may not have been thought to have the wherewithal to make the relevant inquiries in those circumstances. Corrections. If you think something is wrong, correct it. Again, that won't save you from the fact you may have engaged in misleading conduct, but the quicker you correct it, the better. Also, if a statement is true at the time you make it, but turns out to be untrue later, you should do your utmost to correct it as soon as possible. Again, that's not particularly mind-blowing, it's fairly obvious, but it's amazing how many of the obvious little things are forgotten. Brand lines, this is on which we touched on before with Nurofen. It's also been litigated recently with the Emil gel and Osseo gel, the Glaxo against where the ACCC had a claim against or sued GlaxoSmithKline for misleading deceptive conduct. Emil gel was sold as a general pain relief gel, but the Osseo gel was sold specifically to those suffering from osteoarthritis and sold at a higher price, and said, look, if you use it for longer, it'll have better effects. A range of things which represented it was a better product or a different product to the Emil gel, when in fact the two formulations were the same. Quite clearly, that's misleading deceptive conduct because you are marketing things which are the same in very different ways. It happens quite a lot. You'd be surprised at the number of organisations that do this. They create these different brand lines to generate diversity in their products or interest in their products and generate sales and target specific sectors of their consumer base. And this is where they can come unstuck. Puffery is one where it's accepted as part of advertising. People will say things to generally improve their position when it's really just an exaggerated statement. Examples of puffery are things such as, Red Bull gives you wings, the burgers are better at Hungry Jack's, or Starbucks saying they've got the world's best coffee. Quite clearly, none of that is really going to be true necessarily, and everyone understands it's a bit of people were just overblowing things and making a bit of hype around what their products are like. However, be a little bit careful about where that line is drawn. It can be sometimes hard to see. For example, if you are making a statement which has some sort of foundational basis or may have foundational basis, then it may not be puffery. It may actually be misleading or deceptive statements. Example of that is Gillette and Energizer back in 2005, where Energizer were promoting that their battery was the world's longest lasting battery in high-powered devices. That was deemed to be representation and not mere puffery, because there was an inference that maybe there had been testing that had been done or made, and that because of the lack of that basis, it was actually deemed to be misleading, not just mere puffery. Claims, there's lots of these that do go around. People use the words free, green, natural, or organic. Free is a classic one where businesses like to get people engaged in products by using the word free. The idea that you can get something for free is always going to generate interest. Let's say everyone wants something for free where they can get it. But the expectation, the court's view as expectation is that it's absolutely free. And that's a justifiable expectation. Not that it's free with conditions. It's free means without conditions. Free absolutely. So in a nutshell, if it's not actually free, don't say it is. An example is where a business might say, we're going to give you 10% free of a product. But what they've done is actually increase the price of the product, not necessarily by 10%, might be by 5%, but enough that it's actually no longer, that additional 10% is no longer actually free. So it's misleading. The buy one, get one free offer would be misleading, where a company raises the prices of the first good to substantially cover the cost of the second good. Again, you're not really getting a buy one, get one free. That is misleading and deceptive conduct. Oops, I've gone too quick. There we are. A quick one on organics. Actually, no, I think looking at the time, I'll skip on the organics and the naturals one and look at personal liability. So personal liability is also something which you need to take into consideration and be very aware of. The courts are finding directors of companies as liable as joint tortfeasors more and more often. The view being the conduct that is being engaged in by the company is actually being aided and abetted by the people within the organisation, particularly if there's an understanding that what they might be doing could be borderline. And we'll see this in the In-N-Out Burger case, where personal liability was attributed to the directors of #burgers. So don't think that you can hide behind the corporate veil. There are provisions which do mean personal liability is a real risk. In terms of the consequences of getting it wrong, as I said at the beginning, misleading deceptive conduct has less remedies than false and misleading representations. The main one being, of course, with false and misleading representations, you have these pecuniary penalties, as you can see there in the slide. You can also have publicity orders made for misleading representations as well. And that's quite a powerful tool which ACCC often seeks in terms of remedies when it makes claims against organisations. So that's giving a sort of brief rundown of the areas where businesses tend to come unstuck. And so we'll move now to looking at some of the recent cases. The first case I'd like to look at is the recent one with Google and the ACCC. The court, or the ACCC, argued that the way that Google presented its information in relation to location history settings was misleading, and the court actually agreed with them. And this was deemed to be a world-first groundbreaking case, which the ACCC has promoted in its media releases. It also indicates one of the key areas which ACCC has been focusing on recently, and that is digital platforms. So quite clearly, this is a focus. There is a second case against Google that's still in the works, which we're waiting to see a response for. And in terms of where this case is at, it is, I think, still so in the appeal timeframe. So Google may very well appeal this particular case, but I'm not too sure where it has gotten to yet. But anyway, in terms of this particular case, the court ruled that when consumers created a new Google account during the initial setup process of their Android device, Google misrepresented that the location history setting was the only Google account setting that affected whether Google collected, kept, or used personally identifiable data about their location. When in fact, another Google account setting titled Web and App Activity also enabled Google to collect, store, and use personally identifiable location when it was turned on. And that setting was actually turned on by default. So when you set up, it was already on. The court also found that when consumers later accessed the location history settings on their Android devices to turn that setting off, they were also misled because Google did not inform them that by leaving the web and activity settings switched on, Google continued to collect, store, and use their personally identifiable location data. Also, between March 2017 and November 2018, when consumers later accessed web and app activity setting on their Android device, they were also misled because Google did not inform them that the setting was relevant to the collection of personal location data. Now, the case is interesting and of quite broad application because while this focused on the privacy policy which Google had, it could also apply to terms and conditions. If you think back to what we spoke about earlier with some of these internet companies saying, well, you could flick through the terms and conditions, information is available. That may be true, but it's also the whole fine print argument. Where do you put information which is relevant or important in terms of working through particularly mobile devices? And with mobile devices, you've got limited space to put things on. You're going to have multiple screens. There's kind of no real help for it. So this is quite interesting now about what organisations will need to do in terms of conveying that information. Because you've got to summarise the information. It's how you summarise it that's going to often be determinative in this case of whether there's been a breach of Section 19. Now, some of the judge's assessment of user behaviour and what may be reasonable needs to be taken into account by companies, because when we look at the class of people who are affected, it's actually quite a small class, which means there is a greater risk to companies being found to have breached Section 18 if they don't provide the information in an appropriate way. So the ACCC ran its case by dividing Android users into three separate categories. The first involved users who would set up their devices and were shown a particular privacy and terms screen. The second category were users who decided to turn their location history settings off, whether during the setup, the device, or at a later time. The third category of users who decided to turn their web and app activity settings off after having set up the device. These three categories were actually split into further subcategories, but we won't go into that sort of detail. But suffice to say, there were three sort of categories, and the first one, again, looked at the people who were actually setting up their devices. But when we looked at the information that was provided, all users had to view the privacy and terms screen, which gave them an opportunity to either click on one of three buttons to agree, don't create the account, or more options. Now, it's interesting that the parties in this case agreed that most people would just simply blow through the privacy terms and hit agree without looking at the other nested screens or pages. Now, if you think back to a defense is where people should say, well, defense is probably the right word. A defense is where you can prove that somebody should have made reasonable inquiries. It's probably the situation here where people who were given opportunity to look through the web screens and chose not to may not have been misled because they could have made the relevant inquiries and clicked through to the information that was being provided. There was clear click-throughs, information was available, but they just choose not to use it. However, the ACCC recognised it as probably not going to be misleading and deceptive for those particular people. They took that risk of not reading the terms and will suffer the consequences. So they didn't include that group of consumers within their claim. What they did was actually focus on a subset of users, which both parties agreed were atypical, who were interested in privacy-related issues, and did click on the More Options button. On the More Options page, users were presented with a location and a web and activity heading, both of which had an opportunity to click a Learn More button to go to an additional screen with more information. Notably, the web and app activity heading under the More Options screen did not actually include the word location, but instead referred to activity. And this was a key thing in the court's mind. Activity is much broader, and while Google argued that location was encompassed within the term activity, the court didn't agree. And because you didn't have the same terminology, it wouldn't trigger a consideration of the user to think, oh, this relates to my location data, which I'm concerned about. So Google basically lost on that basis to say, well, you didn't provide appropriate disclosure, you didn't provide proper terminology, which would lead people to continue to review the information. Now, Google argued that all the screens should be read as a whole, and tried to argue that people who were going to this sort of length were real privacy geeks and would have really clicked through despite the fact it only said activity rather than location. And the court said, no, we don't agree with that. They said, in their view, Justice Thorley considered that the degree of attention which was paid to screens would have varied according to user interest, but ultimately his honour held that some reasonable users in the first category, which we mentioned, those who just set up their devices, weren't who are going to be privacy geeks. They would not have clicked on all the links necessary to gain a full understanding. They may have had some concern, but not to the extent of going through every single little detail. And for the court, that was a relevant subset of consumers. And because the information wasn't conveyed appropriately, they were misled. And from that particular case, you can see there's going to be quite a lot of, I think, difficulty in determining how information is provided, particularly on mobile devices where there's limited information that can be put on a screen. So quite clearly, care must be taken in some of the paraphrasing that is done and making sure, again, that relevant information is presented in a much more visible and clear manner. This is not the first case that ACCC has run in this area, and the whole sort of consumer privacy issues that's been coined with cases like this is again a focus of the ACCC. And last year they had the Health Engine case where Health Engine was found to mislead consumers because they didn't tell consumers that their information might be shared with third parties. Now in that particular case, despite there being a privacy policy, the privacy policy wasn't clear enough, the information wasn't obvious, or I should say the fact that information might be given to third parties wasn't obvious, was hidden within the fine print, and so Health Engine was held liable. And they were ordered to pay $2.9 million in penalties for that contravention. So as you can see, the penalties are quite significant and are becoming more and more significant as time goes by. The courts are not being particularly lenient in these areas. So time's running away, so I'll quickly get onto the hashtag burgers case. And this is one where there's been a lot of it in the media. When you look at the evidence that was put forward, it's quite clear that these people did the wrong thing, and it's not surprising that the end result was found they were infringing trademarks and engaging in misleading and deceptive conduct. And as the judge said, there's a very fine line between inspiration and misappropriation in this particular case. So looking at the next slide, we'll just give you a bit of a feel for why the conduct was deemed to be misleading and deceptive, and why they were eventually found to be joint tortfeasors. So in 2015, Funkin Burgers, as it was then known, and run by individuals, Messrs. Kagan and Saliba, as sole traders, or in partnership, I should say, had a pop-up burger event. And this event took place after In-N-Out had already had 4 pop-up events of their own. And you can see the In-N-Out burger trademark in the top right-hand corner of the slide there, very distinctive with its yellow and red colours and dynamic arrow logo. You look at the Funkin Burgers logo and it's the same colour, and again, a very dynamic, not an arrow, but a thumbs up indicator. Clearly very similar. But one of the key things in this case was email correspondence between Messrs. Kagan and Saliba and the graphic designer, where they actually said to him, or said to the graphic designer, make a Funkin Burger sign like In-N-Out Burger. So very clearly, there is an intention here to copy or imitate In-N-Out. So moving across to 2016, move from forward, they decided to open another pop-up burger restaurant. This time, they actually changed the name to Down and Out. So Funkin Burgers, not particularly similar, but then Down and Out, cheekily named, using the exact same colour scheme, using the arrow devices, and in, again, email correspondence, Mr. Kagan remarked that D&O becomes Sydney's most controversial burger restaurant. So quite clearly there was knowledge that what they were doing was something very close to the wind and could be viewed as conduct which was misleading and copying In-N-Out Burger. And they were also using other In-N-Out Burger slogans such as Animal Style, Double Double, Ask Us About the Secret Menu. All these things were synonymous with In-N-Out and how In-N-Out presented its products and conducted its business. So in 2016, Messrs. Kagan and Saliba actually got a letter from In-N-Out saying, please stop doing this. We're very flattered that you want to copy what we're doing, but please don't. They wrote back to In-N-Out saying, well, Down and Out is actually about being down in Australia, so down under. It's not the same. We've got a different arrow and everything else. So we don't think we're infringing. But nonetheless, to avoid an argument, we'll change our logos. And in the next column, post the cease and desist request, you can see where they've tried to change their layout and their slogans. The problem was, for Messrs. Kagan and Saliba, was that the conduct which they'd engaged in prior to changing the slogans was too late. In the court's mind, the association had been created because they had used the same colours, they had promoted in a pop-up style, the same as In-N-Out Burger. The whole Down and Out versus In-N-Out was not deemed to be sufficiently different. The judge put a lot of emphasis on the In-Out component of the marks and the reputation which In-N-Out had. And even though In-N-Out was not in Australia at the time, it only had pop-ups, had a good reputation in the US. And look, I for one had not heard of In-N-Out prior to this case, so I must be living under a rock somewhere, or clearly not the relevant consumer that the court would be considering. But the court actually said, no, the way you've handled yourselves, the way you've conducted yourselves through pop-up arrangements, through the use of the colorings, even encouraging people to be confused or ask questions and not really distancing yourself from the fact that you are not In-N-Out or not associated with In-N-Out, you've engaged in misleading and deceptive conduct. And again, when we think back to it's about when the conduct occurred, when it was misleading and deceptive, it happened at an earlier stage. The fact that they've gone and changed the logo down the track didn't save them. It simply was, well, you may have tried to change it, but by that time you've already increased your number of restaurants, you've generated business and income off the back of In-N-Out's reputation by copying and leading people to believe that you are affiliated or producing products which have been condoned by In-N-Out Burger or supported by In-N-Out Burger. The judge then, of course, looked at the personal liability issue and said, because of the conduct that you've engaged in, and you incorporate a company to try and avoid personal liability, but again, that was too late. Your conduct was directed towards engaging in these activities. You clearly knew what you were doing. You continued to do it, and so you're guilty as a joint tortfeasor. So be very careful in terms of how you conduct yourself. Don't always think you can hide behind the company veil there. So quickly turning to these pending cases, But Hungry Jack's and McDonald's, and applying a couple of the things which we discussed today, I think we can all agree that there's a clear intention by Hungry Jack's to leverage off McDonald's Big Mac reputation. It's pretty clear, it's pretty obvious. If you're wondering which burger is which in the graphic there, Hungry Jack's burger is on the left, McDonald's burger on the right. The difference here, and my opinion, is I think Hungry Jack's will probably get away with it, because when you think of the Singtel case and how the judge there assessed, I shouldn't say Singtel, the Optus case, when the judge there said the advertisements about the network coverage were conducted in a way that made it very clear it was Optus, they were using their trademarks heavily. This is what Hungry Jack's have also done. All their ads are very clearly tied to Hungry Jack's. Hungry Jack's has a well-established reputation of its own. It's very unlikely people are going to be misled and deceived that a burger, which might look like a Big Mac, sounds like a Big Mac because it's a Big Jack, they're not going to think it actually comes from McDonald's. All the McDonald's are actually approving the use of Big Jack by Hungry Jack's. The use of the name Big Jack is also part of Hungry Jack's name, and they also say it's a homage to Jack Cowan, who founded Hungry Jack's 50 years ago. So who will be misled and deceived? I find it hard to think anyone will be when you look at the context as a whole, simply because the people who buy burgers, they know the difference between Hungry Jack's and McDonald's. They're not going to be caused to wonder or buy the burger in error by going to Hungry Jack's versus McDonald's. So I think Hungry Jack's will be okay, could be proven wrong, but I think they're going to not be engaging in misleading and deceptive conduct. Now, McDonald's does not own the Big Mac recipe. So when Hungry Jack's makes a burger the way they do, how else would you make it? It's just something which is done that particular way. If you look at the images, the difference is that the Hungry Jack's burger patty is actually on the bottom. So they build it from the bottom up with the patty rather than top down, which McDonald's do. But because the burgers look the same, doesn't mean there's infringement. And McDonald's have no rights over the particular look of that particular burger. They may try and argue that, but I don't think they'll be successful. Also, back in the 1980s, there was another case which McDonald's was involved with McWilliams wines, where McWilliams were marketing a magnum of their wine as the Big Mac and a series of wines as the Big Mac. The court, at first instance, found in favour of McDonald's, but on appeal that was overturned. The court said, well, people who buy wine are probably not going to be always the people who buy burgers, and there's going to be a clear understanding that wine and burgers probably don't go together. There's probably not really going to be an endorsement or an association, and the way the marketing and advertising was done, there was no indication that it was tied to McDonald's. So again, McDonald's have gone down this path before and not been successful. The next case is a pending case, is the Lorna Jane case. This one, Lorna Jane was actually already fined by the Therapeutic Goods Administration some $80,000 last year, pardon me, because they promoted a product which didn't have any approvals from the Therapeutic Goods Administration and was claiming to have certain medical benefits. The ACCC have now got on board and said, well, in addition to that, you've engaged in misleading and deceptive conduct by saying that the actual garments have a certain ability to destroy the virus or destroy viruses and withstand viruses, which there's no foundational basis for. The issue here is also when it was released. This was done back in July last year, and at the height of the COVID pandemic concerns, where people were very, very concerned about COVID, what would happen, where it was going. And when they see an advertisement from Lorna Jane saying, we've got this product which we can spray a substance onto which stops the virus, kills the virus on contact, and protects you, people will buy it because it's also a trusted name. So the Lorna Jane name being very trusted, being released at the time of people were very concerned, maybe not looking to investigate things as close as they may have, would buy the product almost out of, I suppose, just because they felt it would make them safe. And that sort of situation is where I think, in my view, Lorna Jane will probably be found to have been guilty of misleading deceptive conduct. Look at some of the ads. It's very clear. Lorna Jane Shield, there's representation there that you're protected, and it is protecting you. So clearly it's saying something which you want to believe. An antivirus. The word antivirus indicates that it will destroy viruses. If you look at the graphic on the right-hand side, here to protect you. It's groundbreaking technology. It makes transferal of all pathogens to your activewear impossible. It's a very broad statement. And they'll even say, and let's face it, what we're thinking about is COVID-19. So again, that context of when it was released, the nature of the representations made, I think Lorna Jane is going to have a very hard time defending this position and will be found to be engaged in misleading and deceptive conduct. So quickly, I know we're running out of time here. We've run out of time, so quickly just some takeaways and trends. As I said, context is king. You've got to know your audience. When you are promoting products, make sure that you are aware of the people you're selling to or the people who are likely to buy your products. If you can engage a bit of context mapping, that will certainly potentially give you a bit of understanding about the risks that you may have to overcome. There is no decline in the activity of litigation on this particular section. It's happening all the time. There's plenty of cases. As I said at the beginning, it's the most litigated piece of legislation in Australia. The ACCC is vigilant. They're continuing to pursue vigorously companies and individuals. Digital platforms is a clear area where they're focusing, and in 2020 they actually established a permanent digital platforms branch. Word of advice, if the ACCC comes knocking, cooperate where you can as early as possible. The courts don't take a very particular healthy view if you drag the chain and only comply when it's pretty obvious you should have done that months earlier. Training and compliance, which we've touched on before, as said, organisations should make sure they have compliance and training within their organisation. It will help them in the long run. Firstly, to avoid potentially the claims, and secondly, if the claim does come, to possibly reduce penalties. Internal processes and evidence, internal notes and decision-making evidence about how you come to certain decisions is always going to be key. As with the #burger case, the email correspondence between individuals was very telling and damning in that particular case. Be careful with using social media. Social media can go to a large number of people very quickly. A lot of these cases also draw on comments from social media indicating people might be getting confused, and the more people get confused, it could be easier for a claim to be brought. And certainly all this evidence that's available makes it very easy for the ACCC in particular to bring their claims with the evidence that they can collect. Disclosure, it's an obvious one. Make it clear and make it honest. Don't be silent if it's necessary to say something to prevent someone from being misled. Again, some of these things are pretty obvious in terms of what you should do. The application is something a bit harder. With your marketing, make sure you can substantiate your claims and representations. Check that all the material that's been prepared by third parties is accurate. Don't rely on them to do the right thing. Make sure it's accurate for your business and your organisation. And just to quickly round off on the ACCC, what they've been focusing on, as we've seen, they've been looking at the COVID-19 arrangements, and people make representation around COVID-19. The Lorna Jane case is an example of that. There have been consumer issues in the funeral services sector. I personally don't know a whole lot about that, but it's an issue for the ACCC. Digital platforms we've looked at, the ACCC cases against Google, the Health Engine case I referred to as well, and there's further ongoing cases in that area. And of course, we've seen quite a bit of it in the media in the past, and that's about essential services, particularly with energy and telecommunications. Their ongoing focuses for the ACCC in 2021. So that rounds up the session for today. I don't know if there's any questions which have come through. So there's one question here. Have I got an example of a party acting honestly and reasonably but still found to have acted false and misleading or deceptive? I don't actually have an example that springs to mind. Unfortunately, it would be useful if I did, of course. But no, I don't have one. But it has occurred. There have been situations. I just can't think of one which springs to mind straight away. I think that was the only question that has come through, so I apologize I couldn't give you a better answer than that one. I know we've gone over time. I do thank you for your patience, and I hope today's presentation has been useful for you. So I'd just like to end off by thanking you for today, thanking you for your attention today, and that once you leave the webinar, you will receive a short survey on the presentation, and I'd appreciate it if you could provide your feedback. That certainly helps us provide other presentations in the future. There'll also be a follow-up email within 24 hours with a link to a recording of today's webinar along with some handouts. And on behalf of Bardia Perry, thank you for joining us today and have a great rest of the day. Thank you.